Good morning, friends. I hope you all will be in best of your spirit. Today, I am discussing with you the new criminal law, that is BNS, which has replaced Indian Penal Code. If we go by the BNS, it has repealed 22 sections of the Indian Penal Code and amends nearly 175 out of IPC's 511 sections. It has now 20 chapters and 358 sections. Now, going further, you will see that in IPC, there was no definition clause. All the interpretation clauses were spread over sections 8 to 52A of the IPC. The definition in section 50 of the IPC stands omitted by the BNS, as it is now a word of extensive uses in various legislations and it need no definition. Most of these interpretation clauses in section 8 to 52A of the IPC 1860 have been retained in BNS without any change and have been compactly grouped in section 2 of the BNS in alphabetical directory sequence for ease of reading and reference. Going further, you will see that the wording unless context otherwise requires is used while starting section 2. Though most of the interpretation rules in section 8 to 52A of the IPC have been included in section 2 of the BNS without any change. But it must be noted that applicability of these interpretation rules in BNS is subject to requirement of the context of the provision, as all definitions in BNS in section 2 are subject to qualificatory phrase unless the context otherwise requires. Now, going further, definition of child. New definition of child in section 2, subclause 3 of the BNS has been laid. The definition of gender in section 8 of the IPC recognizes only male and female genders. The new definition of gender in section 2, subclause 10 of the BNS recognizes transgender in addition to gender of male and female. As already discussed, the definition of child has been a little bit removed. And you can say it is a new provision. Section 2, subclause 3 of the BNS defines new provision of child. Section 2.3 of the BNS defines child to mean any person below the age of 18 years. Now, there is further section 20 of the IPC, which deals with court, and that is now section 2, subclause 5 of the BNS. In this case, there is little bit change, that is omission of illustration. You will see that illustration below section 20 of the IPC, referring to regulation 7 1816 of the Madras Code, has been omitted from the definition of in section 2, subclause 5 of the BNS. Going further, definition of document, which was earlier defined in section 29 of the IPC, is now defined under section 2, subclause 8 of the BNS. Section 2, subclause 8 of the BNS provides that documents includes electronics and digital record. So this is new edition. Earlier it was not in the IPC. Going further, the gender. Section 8 of the Indian Penal Code deals with it, this gender. And now the section 210 of the BNS deals with it. Now the definition section 210 expressly refers to transgender and defines the term, which was not the case in section of 8 of the IPC. Going further, judge. It was defined under section 19 of the IPC, which is now defined in section 2, subclass 16 of the BNS. As per old law, section 19 of the IPC, the judge was defined in quite detailed manner. It stated that judge includes not only individual officials designated as judge, but also those who have the authority to render definitive judgment in any legal proceeding, whether it is civil or criminal. This definition encompasses individuals who can make judgments that, if not appealed against, would be considered definitive. It also included members of a body of persons authorized by law to render such judgments. The illustrations provided clarify this definition further, including examples of collectors, magistrates, and members of the panchayat. Now, as for new law, that is section 2, subclass 16, the new definition of judge is more concise, and although it follows a similar pattern, the new law aligns with the old law definition but presents the information in a more streamlined manner. Coming further, month and year. It was earlier defined in section 49 of the IPC, which is now defined in section 2, subclass 20 of the BNS. Section 49 of the IPC required year or month to be reckoned as per British calendar. Now section 220 of the BNS requires year or month to be reckoned as per Gregorian calendar. Going further, movable property. It was defined under section 22 of the IPC, which is now defined under section 2, subclass 21 of the BNS. Scope of movable property in section 221 is not limited to property in corporeal form, unlike the definition in section 22 of the IPC. Section 221 of the BNS omits the word are intended to include corporeal before the word property. Earlier in the IPC, it was are intended to include corporeal property, which has been now removed. Therefore, movable property includes property of every description other than immovable property, whether such property is in corporeal, tangible form or not. Definition of movable property under BNSL will include intangible assets like patents, copyrights, as well as actionable claims. Going further, public servant. It was earlier defined under section 21 of the IPC, which is now defined under section 2, subclass 28 of the BNS. Reference to juryman is now omitted from the definition in section 228 of the BNS, which was earlier there in section 21 of the IPC. Local authority is defined by referring to clause 31 of the section 3 of the General Clauses Act 1897, and Section 2, Subclause 45 of the Companies Act 2013. So, local authority defined under General Classes Act and Companies Act. The provision that was there in both the section acts is now there in this new act. Coming to punishments, which was dealt with under section 53 of the IPC, is now dealt under section 4 of the BNS. Section 53 of the IPC provided for 5 types of punishments: death, imprisonment for life, imprisonment which is of two descriptions, rigorous and simple, forfeiture of property, and fine. Now, Section 4, subclause F of the BNS has introduced a new 6th type of punishment, that is community service. So, to reduce the burden on jails, community service has been included in BNS for the first time, and it is being given legal status. BNS prescribes community services as punishment for petty offenses like non-appearance in response to a proclamation, attempt to commit suicide, to compel or restrain exercise of lawful power of public servant, petty thefts on return of theft money, misconduct in public by drunken person, and defamation, etc. The term community service is not defined anywhere in the BNS. However, it is defined by explanation to Section 23 of the BNSS to mean the work which the court may order a convict to perform as a form of punishment that benefits the community for which he shall not be entitled to any remuneration. The punishment of imprisonment for life has been clearly defined as imprisonment for remainder of person's natural life. Earlier, it was a controversial issue as it was having lot of gray area. Now, going further to Section 54 and Section 55 of the IPC, which deals with commutation of sentence. Now it is dealt under Section 5 of the BNS. Changes in computation provision, Section 433 of the CRPC, and now Section 474 of the Bharatiya Nagrik Suraksha Sanhita 2023, BNSS. Now, if we compare Section 433 of the CRPC with Section 474 of the BNSS, the difference is as such. Earlier, sentence of death. Appropriate government may commute a death sentence for any other punishment provided by the Indian Penal Code. Now, death sentence may be computed for imprisonment for life only. Earlier, sentence of imprisonment for life. Sentence may be commuted for imprisonment for a term not exceeding 14 years or for fine. This was earlier provision. Now, under the new act, the provision is the sentence may be computed for imprisonment for a term not less than 7 years. Now, another subject was a sentence for imprisonment for 7 years or more. Earlier, there was no provision for computation. Now, the sentence may be computed for imprisonment for a term not less than 3 years. Now, sentence of rigorous imprisonment, which was earlier. Sentence may be computed for simple imprisonment for any term to which that person might have been sentenced or for fine. There was no limit. Now, in the new act, sentence may be computed for simple imprisonment for a term to which that person might have been sentenced. Earlier, sentence of simple imprisonment. Sentence may be computed for fine. Now, there is no change or there is no mention of that. Sentence for imprisonment for less than 7 years. Earlier, there was no mention. Now, the sentence may be computed for fine. Now, fractions of terms of punishment. These were earlier dealt with Section 57 of the IPC, which are now dealt under Section 6 of the Bharatiya Nyaya Sanhita, that is BNS. Unlike Section 57 of the IPC, Section 6 applies unless otherwise provided. So it starts with unless otherwise provided. The word unless otherwise provided, which were not there in Section 57, has been added in Section 6 at the end of the provision. Now, fine, liability in default of payment of fine, which were dealt under Section 63 to Section 70 of the IPC, have been clubbed under Section 8 of the BNS. IPC only provided for imprisonment in default of fine only, as there was no punishment of community service in IPC. There was also no imprisonment in default of community service in IPC. Consequence upon introduction of new punishment of community service in Section 4 of the BNS by the BNS subsection 4 and 5 of the Section 8 of the BNS provides for imposing imprisonment in default of community service. Fine of community service and default in payment of fine. Under old law, for default in payment, the following were the provision. Where the fine was not exceeding 50, imprisonment was up to 2 months. Where fine not exceeding 100, it was up to 4 months. And in any other case, it was up to 6 months. Now, under the new BNS, for default in payment of fine or community service, the new provision is if the fine is not exceeding 5,000, or you can say community service, then imprisonment should not exceed 2 months. Where the fine not exceeding 10,000 for community service, imprisonment shall not exceed 4 months. And in any other case, imprisonment should not exceed 1 year. Now, there was provision of private defense of property when right of extends to causing death. This was dealt under Section 103 of the IPC, which is now dealt under Section 41 of the BNS. Old law provided for house breaking by night. Now, it is provided that house breaking after sunset and before sunrise. So the wording house breaking by night has been changed to house breaking after sunset and before sunrise. Section 103 of the CRPC provided for mischief by fire, which has been now changed to mischief by fire, or any explosive substance. Now, again, private defense of property, when it will commence and continuation of right to defend. It was earlier dealt with under Section 105 of the IPC, which is now Section 43 of the BNS. Section 105 of the IPC provided for housebreaking by night. Now it provides for housebreaking after sunset and before sunrise. Now there is new provision, that is Section 48 of the BNS, which talks about abatement outside India for offences in India. Section 48 of the BNS provides that a person abets an offence within the meaning of this Sanhita, who, without and beyond India, abets the commission of any act in India which would constitute an offence if committed in India. So, abatement by a person outside India has been made an offence under Section 48 to allow prosecution of person located in foreign country. Abetting commission of offence by public or by more than 10 persons. Section 117 of the IPC, which is now Section 57 of the BNS. Section 117 of the IPC provided for imprisonment up to 3 years or fine or both. The new section, that is Section 57 of the BNS, provides for imprisonment of either description for a term which may extend to 7 years and fine. Now, coming to most serious section offense, that is rape. It was earlier defined under Section 375 of the IPC, which is now Section 63 of the BNS. What is the change? Exception to Section 63 of the BNS provides that sexual intercourse or sexual act by a man with his own wife, the wife not being under 18 years of age, is not rape. While under Section 375, the age limit was 15 years. Now it has been increased up to 18 years. So up to 18 years, if the girl is 18 years, the wife is 18 years or more, then this is not offense. Now, punishment for rape, which was earlier dealt under Section 376 of the IPC, which is now Section 64 of the BNS. Clause I of Section 62, subclause 2 of the BNS provides for commits rape on a woman incapable of giving consent. The wording is commits rape on a woman incapable of giving consent. While the earlier wording was commits rape on woman when she is under 16 years of age. So this wording commits rape on woman when she is under 16 years of age has been changed to commits rape on a woman incapable of giving consent. So age limit for particular category of situation has been unlimited. Punishment for in certain other cases of rape, such as Section 376 AB of the IPC, which is now covered under Section 65 of the BNS. Section 65 of the BNS combines both age categories, under 12 and under 16, into a single section, simplifying the legal framework. Earlier, under Section 376 AB, it was classified into two categories, under 12 and under 16. Now it is now a single section covering both the categories. Another section, sexual intercourse by employing deceitful means. This is new provision. Earlier it was not there. So section 69 of the BNS is a new provision. Section 69 of the BNS provides that whoever, the wording is whoever, by deceitful means or making by promise to marry a woman without any intention of fulfilling the same and had sexual intercourse with her. Such sexual intercourse, not amounting to the offense of rape, shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Now, deceitful means have been further defined, which include false promise of employment or promotion or inducement or marrying after suppressing identity. Now, coming to other serious offense, that is gang rape. It was defined under various sections, that is 376D to 376DB of the IPC, which has now been clubbed under section 70 of the BNS. Death sentence was provided under section 376DB of the IPC for gang rape of women under 16 years of age. No death penalty was provided for gang rape of women aged below 16 but above 12 in section 376 DA. Now section 70 subclause 2 of the BNS provides death penalty for gang rape of a woman under 18 years of age, which was earlier 12 years of age. Now it is 18 years of age. Assault or use of criminal force with intent to disrobe women. Section 354B of the IPC, which is now Section 76 of the BNS. It has now been made gender neutral. The word whoever is used in Section 76 and 77 of the BNS. Earlier, word man has been used in the IPC. So man has been changed to whoever. Similarly, in section 354C of the IPC, which deals with voyeurism, is now section 77 of the BNS. Again, whoever is used in the new section against word man in the OIPC. Now, enticing or taking away or detaining with criminal intent a married woman. Section 498 of the IPC, which is now Section 84 of the BNS. Earlier, the wording was woman under husband care or any other person. Now, words from that man or from any person having the care of her on behalf of that man are omitted from section from 498 of IPC. The section Unlike Section 498 of IPC, offences under Section 84 is committed whether or not a married woman is taken or enticed away from her husband or from any person having care of her on behalf of her husband. Section 484 protects a married woman whether or not she is living in the care of her husband or any other person who is taking care of her on behalf of her husband. Hiring, employing, or engaging child to commit an offense. This is new provision under Section 95 of the BNS. Section 95 of the BNS provides that whoever, the wording is whoever, hires, employs, or engages any person below the age of 18 years to commit an offense shall be punished with imprisonment of either description or fine provided for that offense, as if the offense has been committed by such person himself. Hiring, employing, engaging, or using a child for sexual exploitation or pornography is covered within the meaning of this section. Coming to procuration of child, section 366A of the IPC, which is now 96 of the BNS. Section, this section has been made gender neutral. Section 366A of the IPC provided for offences of procuration of minor girl under the age of 18 years. Earlier, the word was minor girl below the age of 18 years. Now, the section 96 of the BNS deals with offense of procuration of any child below the age of 18 years. So, this is irrespective of gender. It can be any child, not only minor girl. The protection accorded by Section 96 of the BNSL to children is wider than accorded under Section 366A of the IPC. Since protection under Section 96 is available to all children, irrespective of gender, which Section 366A protected only minor girls. Now, again, selling child for purposes of prostitution. This was Section 372 of the IPC, which is now Section 98 of the BNS. The word child is now substituted for any person. Now, buying child for purpose of prostitution, which was Section 373 of the IPC and now Section 99 of the BNS. The word child is substituted for person in Section 99 of the BNS. Imprisonment prescribed for is not less than 7 years, but which may extend to 14 years. It was earlier 10 years. So there is change in imprisonment punishment also. Now the new section, move launching, means murdering. Earlier section 302 of the IPC talked about murder. And now the murder is defined under section 103 subclause 1. But there is addition of new provision 103 section subsection 2. Section 103 subsection 2 of the BNS provides that when a group of 5 or more persons acting in concert commits murder on the ground of race, caste, community, sex, place of birth, language, personal belief, or any other ground, each member of such a group shall be punished with death or imprisonment for life and shall also be liable to fine. Now, going further, punishment for murder by life convict, which was dealt under Section 303 of the IPC, is now dealt under Section 104 of the BNS. Unlike IPC, it is not mandatory to a death sentence for murder by life convict. Now, the BNS gives an option to the judge to sentence the life convict murderer to death or with imprisonment for life, which shall mean the remainder of that person's natural life. Going further, culpable homicide for not amounting to murder and punishment for the same. It was Section 304 of the IPC, which is now Section 105 of the BNS. Section 105 of the BNS prescribes imprisonment of not less than 5 years, which may extend to 10 years. With fine. It was up to 10 years with fine or both under Section 304 of the IPC. Now there is another provision, lesser punishment if accused reports the case to the police and takes the victim to hospital for medical treatment. This is for death causing under Section 304A, death by negligence. It is Section 304A of the IPC, which is now Section 106 of the BNS. Section 106 subclause 1 of the BNS provides that whoever causes death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description for a term which may extend to 5 years. The new law increases the imprisonment for causing death by negligence from a maximum of 2 years to maximum 5 years. This change refers to a stricter approach to cases of negligence resulting in death. Offender escaping or failing to report. This is new provision under Section 106, subclause 2. Section 106, subclause 2 introduces an additional provision in subsection 2 to Section 106 of the BNS, which addresses situations where the offender escapes from the scene of incident without reporting it to the police officer or magistrate after the incident. In such cases, the punishment is very hard, with a maximum term of imprisonment of 10 years with fine. As the instances of hit and run cases are on the rise, a new provision under Section 106 subclause 2 of the BNS has been made. Currently, hit and run cases resulting in death due to reckless and negligent driving are registered under Section 304A of the IPC with maximum penalty of 2 years of imprisonment. If we go by the daily road crash report of 2021, there are 555 cases where registration number of vehicle involved in the crimes are unknown, signifying hit and run cases. The Honorable Supreme Court had, in several cases, observed on the inadequacy of law in view of the increased vehicular accident. To address this issue, this new provision has been introduced under Section 106, Subclause 2, which was long due. Section 106.2 so has been introduced to cover the hit and run accidents and to ensure reporting of accident immediately. This has been introduced with an aim to save the victim within the critical golden hour, a term introduced in the Motor Vehicle Act 1988 in the year 2019. Punishment under Section 106 Supply 2 is not attracted merely by virtue of driver escaping from the scene of the accident to escape the wrath of bystander who might move launching him. So offence is only committed if escape from scene is coupled with non-reporting by him to police magistrate soon after the incident. So he had to report to the police or magistrate soon after the incident. There is no provision for also medical practitioners. In case of registered medical practitioners, if negligent act is done by a registered medical practitioner while performing medical procedure, he shall be punished with imprisonment of either description for a term which may extend to 2 years and shall also be liable to fine. For the purpose of this subsection, registered medical practitioner means a medical practitioner who possesses any medical qualification recognized under the National Medical Commission Act 2019 and whose name has been entered in the National Medical Register or a state medical register under the Act. Suicide of child or person of unsound mind and abandonment of. So, abatement of suicide of child or abatement of persons of unsound mind. Earlier, insane person or any idiot in section 305 of the IPC was used, which is now replaced to persons of unsound mind. Attempt to murder 307, which is now dealt under section 109 of the BNS. Under section 307 of the IPC, it prescribed only death penalty for attempt to murder by a life convict. For attempt to murder by life convict, section 109 of the BNS provides for death or with imprisonment for life, which shall mean the remainder of that person's natural life. Now, there is new section, organized crime, which is defined under section 111 of the BNS, which is lengthier one, and organized crime, petty organized crime. This is also new section defined under section 112. Then there is new section, Terrorist Act, defined under section 113 of the BNS. So this was all about this new criminal law, that is Bharatiya Nyaya Sanhita 2023. I hope you enjoy well. For more clarifications on any topic relating to this, you can dial me or WhatsApp me. My contact number is 988 That's all. God bless you all.